Good morning. My name is Harry Dyson. I'm joined by Elliot Kay, my colleague at King's Chambers, both part of the construction team here. This is the first talk in the King's Chambers series of construction seminars. And Elliot and I today intend to start with the more basic of disputes, the construction disputes that occur in the county court. So what Elliot and I set out to do, and with this talk, is not to talk about your larger disputes that are necessarily going to be in the TCC or JCT disputes, all of that sort of thing. This is really focused on the disputes that are often involving a residential premises, with homeowners instructing builders to either do renovation works, build extensions, or larger scale works. But it tends to really be residential premises. But that said, much of what we have to say today translates just as well to when it's a commercial premises being worked on, or anything, or any number of different sort of construction disputes that might find themselves in the county court. So it isn't exclusively residential premises, but that is the focus of where we find a lot of cases end up being involved with. So for the purpose of today's talk, we will refer to, if we refer to the claimant, we are going to be talking about the property owner or the employer, to use the construction language. And when we talk about the defendant, we will be talking about the contractor, the builder, or whichever trade it might be. Of course, in many disputes, it's often the other way around. The contractor will put in their final invoice and claim on the back of that, and then it will be the counterclaim alleging defective works. But for the purpose of this, to keep things more streamlined and straightforward, and that's how we're going to address the parties, broadly speaking. So that's the background to the talk. In terms of going forwards, the slides will be published afterwards. And any questions as we go along, there's the Q&A feature. We find that works a little bit better than the chat box because they're easy to keep track of. But we do have some questions that were put in advance, and we have had time to answer a few of those. So we're already going to be dealing with those. It will really be time dependent whether we get to any questions during the seminar. But our contact will be contactable in Chambers afterwards if any questions are left not dealt with. So don't worry. So to start then, the first point that Elliot and I will be talking about are experts. Extremely important in these cases. Any construction dispute will in reality require expert evidence where there's any question marks over the quality of the works, or whether or not there was works missing or anything like that. You will almost always need expert evidence. I'll run through the slide in a moment, but that sets out some questions and some issues you need to be looking at. But the point that Ellie and I wanted to stress was that once you start this litigation, you are likely to be wedded to your expert for the duration of the dispute. That's not to say you can't get a new expert if something happens, but in reality, and keeping cost proportionate, once you start on the journey with the expert, you are likely to be stuck with them, for want of a better phrase, throughout. So looking, when it comes to selecting the right expert, don't be under any illusions. This is not easy. Finding an expert that's good and within the locality, broadly speaking, of property, is not easy and can be a massive challenge in these cases. But the questions you need to be asking yourself are, do they have experience as a expert witness? So they may be the best surveyor in the world, but if they've never written a Part 35 compliant report or appeared in court, they might not be the appropriate expert. In fact, in all likelihood, they won't be. Do they have a particular specialism? And again, you need to look at your specific dispute. If it's a general building contract where they've done everything to put the roof on to lay the groundworks, you perhaps don't want a surveyor that's too specialist. But if this is all a dispute purely about drainage, for example, then perhaps a specialist is more what you need to be looking out for. Or, for example, do they have more than one specialism? And always bearing in mind that expert evidence is always really at the will of the court. So there will be some times where judges limit you to only perhaps having one expert each. So perhaps you'll want a surveyor that's a quantity surveyor and perhaps even a structural surveyor as well. And they do exist, perhaps more difficult to find, but it may be the case that you can have one expert that does everything or you may need to get more than one. But again, all questions that you need to be asking, and the earlier you ask them, the better. In my experience, and I'm sure it accords with Elliot's experience as well, is often both sides will have surveyors. When they come to a particular thorny issue, for example, there's nearly always a question over the size of a steel beam that's been put in. Often they will say, I'm not a structural engineer, structural surveyor, and I'm not advising on that issue. That is really, really common. So keep that in mind. If there is any big issues like that, ask your expert before you instruct them. Is this the sort of thing you can deal with? And likewise, communicate with the other side. It may well be the fact that you need a structural surveyor. And again, that's something that can be a really easy one to agree to have a single joint expert. You may well both insist on your own experts generally, but when it comes to the structural issues, you can get a single joint expert as well. So you don't necessarily have to be completely wedded to having your own experts or having a single joint expert. There's always a middle ground. That brings me neatly on to the issue of single joint experts. They can be brilliant in cases, and often the feeling is, well, we don't want to commit to a single joint expert because they will determine the dispute. If that expert finds against us, then what do we do? All I would say is don't worry too much about that, because there is, frankly, plenty you can do. You can put questions to the experts, and if need be, you can call them in to be cross-examined. Only 2 weeks ago, I had back a reserve judgment where we'd done exactly that. And we'd called in the single joint expert and put them to prove on several matters how he explained his conclusions. And the judge ended up finding against what the expert had to say in many aspects. So don't fear the single joint expert. It certainly can be a great way of keeping costs down. And again, all I would say is, in terms of experts, as a last point on this slide, is don't be tempted by any well-known pro-claimant experts. Any of you that do housing disrepair work, for example, or ever come across it, or issues like that, you'll see the same name of experts cropping up time and time again that are for the claimant and always publish a pro-claimant report. Don't be tempted into using those, even though you think it would help, because often the quality of that expert evidence isn't the best when it really comes to be tested.
Now, as Harry's touched on, your expert evidence is likely to be crucial evidence as a case progresses. And it's very important that you get the most from your expert. And what I mean by that is that you maximise the effect of your expert evidence, because as lawyers, we aren't surveyors, judges aren't surveyors, and the judge will need guidance on the issues which require expert evidence. And in more cases than not, expert evidence often determines the outcome of any trial, and it's very important that you understand each and every part of your expert evidence before you get to trial. You'd be amazed how many cases involve lawyers who think, well, we've got some expert evidence, we can simply go along with that, stand behind that, and run it to trial on the basis of what our expert says. And there's a lot more that you as a representative can do with your expert evidence than that. So, for example, it's very important that you understand precisely why your expert reaches the conclusions that he or she does. And one way of doing that is to have a site visit with your expert, armed with the report that they've prepared, and to go through it with them, and to make sure that you fully understand how they've reached their conclusions and why they have reached those conclusions. And the reason that's so important is that when the other side's expert evidence comes in, or when it becomes time for preparing joint statements between the experts, it's very important that you can form your own view as to where their expert can be challenged, where they're weaker in the case, issues that we can challenge more robustly, issues that we need to be slightly more considered about, and maybe think there might be issues we can agree ahead of any trial. So it's very important that you don't just get an expert report, accept what it says, and do nothing more. It's very important that you understand each and every element of it. And I always find that solicitors and counsel who have that understanding are much better placed as a trial approaches, or any settlement negotiations are on the table, or anything of that nature, are much better placed than those who have just stood behind their expert evidence and ran a claim on the basis of it without fully understanding what's in there. there are cases where it'd be disproportionate to have a site visit with your expert, but if it's one of those cases where there is a lot to be gained from the expert evidence and a lot will turn on it, I really would recommend having a site visit with your expert. Of course, I'm sure you all do it anyway, but having conferences with your experts is crucial. We'll come on to that in due course. But really understanding your expert evidence is a key part of construction litigation in the county court.
Yeah, I would echo all of that. And we've had a question through which might be convenient to deal with now. And I think if I understand the question properly, what it's asking is, well, there are situations where letters of claim come with the attachment of a CPR Part 35 compliant expert report at that stage. So the question is, well, this report's come out before issues might have crystallised, before we've had witness statements or disclosure or anything like that. And I think that the question really is asking what we think of that. It's difficult in these cases, I think, because to plead a case properly often and to plead it with sufficient particularity and to do it properly, basically, you do need an expert report. It doesn't necessarily have to be Part 35 compliant at that stage. Sometimes litigants save money by having a more informal report, just pointing out what the issues are so you can plead it. This often works well where there might be less issues. For example, if it's only a roof that has an issue, you might get an informal report that just outlines the issues. But I think there's nothing wrong with getting your Part 35 report straight away before you plead your case. Frankly, it will allow counsel to plead a proper and full case. And all it does mean is that when you come to the expert phase, you don't need to get another report. You might get your report updated. That's quite common, especially if there's been a long passage of time. You might get the quantum part updated, or there might be a little bit of an update, which is sort of a reply to the other side's report. That's often not ideal. We'll come on to that in due course, but you can get them updated. The only thing I would say on that one is don't be fooled that just because you pay for your Part 35 report, that you are immune from there being an order for a single joint expert. You are not. I had a director's hearing about 6 months ago now. The other side had an all singing, all dancing, actually a very good report that would have cost them perhaps up to £2,000 report. We went and asked very nicely for a single joint expert to keep costs down, and the judge thought it was a good idea, and that their original report now is not going to be before the judge. It's now irrelevant. It's gone in someone's filing cabinet. So they spent all that money and they're not going to get it back. So that's the only thing I would say. The only caveat to that advice is don't assume that you're going to be allowed to rely on it. You may end up with a single joint expert anyway.
Just to re-emphasise one of the points Harry made there, having some form of expert evidence when you're pleading your case is very, very, very helpful as counsel. Because it gives you a level of understanding of the case and the real issues in the case, number one, but it also gives you something to adopt in the actual pleading. So when you're pleading, for example, a schedule of defects, having some technical understanding of the real issues is really very, very helpful to actually set out in your particulars or your defence or your counterclaim, whatever it happens to be. Now, if you haven't got that, it means that your pleadings are actually quite woolly and quite vague. Now, obviously, there are some cases where that will give rise to a later application to amend your pleadings, which is going to come with a cost consequence anyway. So, in my view, it's better to get something early doors because it helps both solicitors and counsel advance a much more accurate case early doors than if you don't get that report. So I would really recommend getting an early report, even if it's not your final one, as Harry says, even if it's not Part 35 compliant, getting something will help.
Yeah, no, I agree. And there's been another question. Can a party change its expert at the CCMC even though it was relied on his expert pre-action and part of its defence? I think to answer that question in full would take perhaps a couple of slides, because you're into the full realms of Part 35 and what you can and can't do. All I would say as a broad overview is you will be accused of expert shopping, potentially. If, for example, you don't like the findings of your expert, but I mean, if you relied on it in defence, you probably didn't have too much of an issue. If it's the case that your expert has since turned around and said, I'm retiring, or I no longer do court work, or actually I've bitten off more than I can chew, I shouldn't really be doing this, and I should say I've had all three responses from experts in the cases I've dealt with, there's nothing wrong then with having to get a new expert, because that is not expert shopping. That is just being frankly let down without criticizing the expert. That's just been let down by your expert. So it really is fact specific on what's happened, but don't worry. It's often not as big a deal as what you might think. I don't know if Elliot has had any particular experience of that, but that's what I'd say. Without going into Part 35, I'd just say, yes, it's possible, but you need to be very careful.
I would endorse that. There are a number of things that you'd also have to consider about proportionality. So if you've obtained a report, but it turns out that you need to change it or whatever, or you need to either change the identity or the subject matter of your expert evidence, then there could be an issue with cost recoverability later down the line. So it wouldn't be an ideal position to change, but it's not impossible.
Yeah, I've added another question actually, which I can deal with quite quickly. Agreeing a joint letter of instruction. Essentially, if you can't agree, if a single joint expert's been ordered, then you'll have to go to court and battle it out over the terms of the instruction. I've had that before, not uncommon, but be warned, judges will take a very dim view of it, and cost-wise, you need to make sure that every letter you send is one you want to be read out in court. But that this particular question says that we want to agree a joint letter of instruction, but one side, which is very common, says, well, it's irrelevant because that wasn't part of the quote, therefore, it's got nothing to do with us. The other side says, well, it was part of the quote, so it is relevant. And I think the question is, well, on that basis, we're struggling to agree letters of instruction. What I would say is, there is nothing wrong with having an expert opine on a matter that you say is not part of the contract and we didn't even do the work, because that is a finding of fact for the trial judge. So even if the expert finds that, I think the drainage was awful and wasn't done properly, that's fine, because if you establish as a matter of fact that your client didn't do the work, then it's not a problem. So my advice would be, when it comes to dispute of fact, which isn't uncommon, don't let that stop you the letter of instruction. Of course, the other issue is the cost, whether that little bit will add to a lot more costs. I think that's the crux of this question, that it will. In that situation, it really difficult to advise on, to be honest. And it, like we keep saying, it is proportionality, but it sounds like that might be the only way to get to the bottom of your dispute. So again, it sounds like that's just a difficult position that individual's found himself in with the letter of instruction, I'm afraid. And as I say, there's not always easy answers to these questions. It can get very, very difficult. I should say, the individual that answered that, if you'd like to get in touch afterwards for a more informal chat, for some more specific points, I'd be happy to do that. The next slide you should hopefully all see is common issues with reports. Now, this is something Elliot and I talked about, and it's a bit of a personal bugbear of mine of how poor a lot of the reports are. And what's especially grating in these situations is often the dispute is, say there might be a £10,000 final invoice, and the counterclaim for the remedies of the defects, we say might be £30,000, something like that. And then you have these reports that cost about £2,000 each. They're a lot of money compared to the amount in dispute, really. And then when you get reports back that are not very good, it's really, really frustrating. So what I would say is keep an eye out for these common issues, bearing this in mind. If you don't have experts appearing to give evidence live in court to be cross-examined, which is probably the norm in lower value construction disputes in the county court, the judges will have to weigh the quality of the evidence and which one they're going to favour based on the document itself. Reading it, how well it reads, how convincing it is. And of course, judges are only human. If it's easier to follow and easier to understand, then they're more likely to favour it. So keep that in mind. So the first one, poorly structured. In my experience, this is when experts talk in long narrative prose. They'll talk on and on and on about one issue and then come to another one. And then later on, they'll return to that same issue, which is a nightmare. For example, think of us poor counsel when we come to reference things in our skeleton argument. We want to say issue 5 on the Scot Schedule, be it a leaky roof, is dealt with at paragraphs X, Y, and Z. And hopefully those paragraphs are in succession. It's the same part of the report. What's really difficult is when you have to pull together 5 different parts of the report where they've been dealt with, frankly, as they've just come up in this monologue that the experts put together. So structure is really, really important. Next one, poorly particularized conclusions. This is a very common one where the expert will say, in my opinion, the only solution is to completely rebuild this element of the works. and with absolutely no explanation as to why that's the case. I was in a case, a 3-day case in Leeds earlier this year, and the expert essentially said the whole roof needs to come off and a new roof needs to go on. This was the other side's expert with very little explanation as to why. Under cross-examination, the expert identified 3 points as to why, and he couldn't explain as to why they couldn't be dealt with in isolation to keep the original roof on. In short, the judge found his conclusion to be absolutely baseless. But again, goes back to what Elliot was saying, understand why your expert says what they say. Had they cross-examined, well, a bit nicer, but had they questioned their own expert about this, they would have found out that really the conclusion was baseless a long way before the trial. So if you do have poorly particularised conclusions, one, a judge will not place much weight in them, and second, you cannot challenge and analyse your own evidence. You simply can't. So what I would say is look for where there is shortfall narrative conclusions backed up with a Scot Schedule. Now, we'll come on schedules in due course, but I think short, punchy conclusions where appropriate are really helpful. The other issues, spelling mistakes, it may seem minor, but again, the judge is analysing the quality and the credibility of this report. If there are spelling mistakes, that just shows that an expert has written it once in one sitting, never looked at it again and emailed it off. That is not the hallmark of a careful and diligent expert witness. It just isn't. Next point, focuses too heavily on being in response to the other side's report. You see this time and time again. Often the situation where the claimant, the property owner, publishes their report, discloses their report with their pleadings. The defendant builder gets the report in reply, and essentially the defendant expert just sets out to trash the claimant's expert's report, and every inch of it is just a rebuttal to what the other side have said. That is not the purpose of the report. The report is, albeit instructed by one side, you are still giving an objective expert's opinion on the quality of the work. It is not for the experts to start litigating the dispute in the report, and it doesn't go down well with judges. Those particular reports are not easy to follow, and it's not helpful. So if you do get a report back that is simply a rebuttal of the other side's evidence, really, really think about whether that's the sort of evidence you want to be putting forwards. Next, the last two really, Part 35 and Part 35 compliance. Now, this is a term that's sort of bandied around a lot. You'll find, it needs to be Part 35 compliant. Actually take the time to read Part 35 and the practice direction. It's not the most fun reading you'll ever do, but make sure the report is actually compliant. And the biggest one in this is the statement of truth. You will be amazed by the variations of weird and wonderful statements of truth and long declarations you see at the end of different reports. In my experience, it's been up to 50-50 that aren't quite compliant. Often you get those that pretty much are, but they might be the odd point to take if you get a difficult opposition. But if they do send you on with the wrong statement of truth, politely point it out to them and frankly send it back to them to put the proper one on. Of course, as long as they're comfortable signing it. So those are the common issues. Look out for them. And what I would say is don't shirk away from sending something back to the expert and saying, look, this isn't good enough for these reasons. At the end of the day, you're paying for, or your clients are paying for a product from that expert, and it should be good enough. But we'll come on to that a bit more in due course. But that's what I have to say, my common gripes with expert reports.
Yeah, and I fully agree with all those common gripes. And I also think that they're all very avoidable if we as lawyers take our time to fully get to grips with the expert's evidence and make sure we fully understand it and that we are comfortable with what our expert says and why. And just like Harry said a moment ago about making sure you're happy with all your emails being read out in court, and make sure you could answer, if questioned, why an expert reaches the conclusions that they do, because that is ultimately what will come out in the water to trial. The point about Part 35 compliance, it sounds silly, but you'd be amazed how often it's missed. I actually did a trial a couple of years ago where there was no Part 35 declaration on the other side's report, and we'd raised it in correspondence early on in the litigation. It'd been brought to their attention, but they just did nothing about it. And then in the lead up to the trial, we ummed and ahed about whether we should make an application in respect of it to effectively debar them from relying on it for the non-compliance. And ultimately, we decided that tactically it'd be better to not do that, because in all likelihood, the court would allow them to serve a compliant report, because we'd had joint statements, we'd had partly tried questions to the experts, etc., and they'd likely, we thought, let them rectify that initial mistake. So instead, what we did was we let them call their expert to give evidence, and that was. It turned out to be a very good decision, because their expert went in the box and had no awareness of Part 35, didn't appreciate that he in fact owed his duty to the court, didn't understand the relevant parts of the Part 35 duty, and it gave us so much ground for cross-examination that set up submissions that allowed the judge to effectively reject the entirety of their expert evidence, because he was effectively acting as an advocate for the other party as opposed to an expert with a duty to the court. And that's something which, had the other side got to grips with their expert, had they have challenged him, had they have tested his conclusions, had they have, frankly, just looked at the face of the report, they would have identified all those issues and they would have been able to avoid them. And instead, the whole case turned against them on the expert evidence for what's really quite straightforward non-compliance. So you don't want to be in that position, and it's very easily avoided. So please make sure that you do.
So the next one, handling expert phase, and I think we've had a few questions which we can probably deal with now. It's quite timely. How do you deal with these issues without being accused of influencing or tampering with the expert's report? What I would say is, again, whenever you're in any doubt about all of this, read 35 again, read the practice direction. But I think what I would say in terms of tampering of an expert's report, I don't see anything wrong with going back to an expert and saying, proofread this document again, or can you help us with a better structure? You are not tampering with the conclusions themselves. You are not tampering with their analysis or anything like that. All you're asking for is it presented in a better format, for example. There'd be nothing. I don't see anything wrong with that, Elliot. I don't know if you strongly disagree.
No, I don't strongly disagree at all. But I suppose this goes hand in glove with making sure that you've selected an experienced and appropriate expert, because an experienced expert will know that they owe their overriding duty to the court, number one. So they shouldn't require, if you selected your expert correctly, there shouldn't be too much that needs to be done. But if there is, your communication with them is likely to be privileged. Your expert should also have the backbone to say to you, if they think you're going too far, that I'm not prepared to do that. You, of course, ultimately have the option to abandon that expert and not rely on their expert evidence and go instruct another one. I appreciate there may be some cost implications there, but if their evidence is so poor that you don't want to rely on it, then that's ultimately what you have to do. It's better that you spend a couple of thousand more potentially than to run a case on the basis of an expert who it's turned out isn't very good at all. So I don't think that there would be a huge risk of that, and you as lawyers know where the lines are and know not to cross them. But you shouldn't be shy of asking your experts to amend their report if they need it.
Yeah, and another question we've had is how often do you see letter of instructions to experts which are leading, sort of leading the expert to a conclusion? How do we deal with that on cross-examination? I think you have to be specific, really, in terms of how you deal with it on cross-examination. If the letter of instruction is asking the expert to rely on matters of fact, and that the expert then doesn't clarify or verify, then you have some really good points to make on cross-examination. If the letter of instruction openly trashes the work that's been done or leads them to a conclusion and you cross-examine it, often you'll just get the response, well, I deal with biased parties all the time, but I'm an independent expert. So it doesn't necessarily cut as sharply as you might hope, only if the expert has allowed themselves to not verified matters of fact. So you have to be really specific about what you can pull them up on, really. So if they've been instructed by a party that is openly partisan and openly critical of the works, that's pretty much the norm. It really is case specific. But again, if you can catch an example of where an expert hasn't verified a matter of fact they've been told, then it's really getting underway to have some good questions then. But it depends. Elliot will have similar experience, I would imagine.
I do, but one thing in particular that you should be wary of is I'm not sure that we'd encounter the actual letters of instruction. It'd be rare to have those disclosed. There may be a case when it'd be appropriate. But the requirements of Practice Directive 35, I think it's paragraph 3.2, require experts to set out the basis of their instructions in their report. So if, for example, a report doesn't set out the basis of the instruction, then that might be something that could be cross-examined on, because it might lead to a suspicion that they've not included the instructions because there's something awry with them. But equally, when you send your letters of instruction, you should be prepared for a compliant expert to include either extracts from that letter of instruction or a summary of it in the content of their report, because that's what the Practice Direction to Part 35 requires from them. So bear in mind that your letter of instruction could feature in that report in some way, and could form the basis, as you say, of some sort of cross-examination and trial if appropriate. About dealing with spelling mistakes, track changes are fine. Absolutely, yes. Track changes and allowing them to accept or reject them. And similarly, you could do that with changes that aren't significant but nonetheless need to be made. If there's a chronological issue, for example, or a factual issue that they've misdescribed or just mispresented, track changes are absolutely fine. If there's something more substantial, I would always prefer to have a conference with them, and I'd prefer to do that solicitor and counsel, so that all lawyers involved on the same side can really get to grips with the expert's evidence and make sure they understand why any variations need to be made, but also so the expert has a right to respond, because the expert's better placed than any of us to understand the technical issues. And if that expert's going to say to you, no, this can't be changed for this reason because it would be wrong for X, Y, or Z, which they will pick up on, or just because it's wrong as a matter of a fact, then it's better that we all know that. And also, as I keep saying, the reasons why. We don't just want to know what the experts say, we want to know why they say it.
Yeah, absolutely. And we're really getting to the nitty-gritty now of handling the expert phase. Now, on the slide, we've already dealt with some of that, so I think I can summarise in these terms. Manage the timeline of the dispute. This applies, this is the sort of nugget of advice that applies to any area of law, but really, often what you'll have, if you're defending, say, the claim will be issued, you'll read their report, your client will tell you it's nonsense, then you'll exchange pleadings, you'll exchange DQs, then you'll be at the first directions hearing, and you'll be given something like 8 weeks to go up and get a report. Unless it's this side of Christmas, or it's the summer holidays or something like that, you'll be given your 8 weeks or a reasonable period like that. Now, that sounds a long time when you sat at the case management conference, but it often isn't to find an expert. So managing the timeline of the dispute, because if you are defending, as soon as you get in that pleading and that Part 35 report, or any sort of report, or anything, frankly, just the pleading, start thinking about your expert. Start thinking about where you're going to find one. If your dispute is in the centre of Leeds or the centre of Manchester, you're not going to have any geographical issues. If you are the back end of Cumbria or down in Cornwall, you may well have serious geographical issues getting an expert to come out to look at the property. The sooner you start thinking about this, the better. If you are struggling to get an expert within the time allowed by the court, make an application to vary the directions. Don't just suffer having any old expert that you manage to drag in at the last minute. I've seen it done with varying levels of success. It's no criticism of those solicitors dealing with those disputes. There are instances where you simply can't do anything about it. But if you think, give it a bit more time, you can make the application. So what I would say is, keep a detailed log of when you've looked at experts, when you've done your research, in what experts you've contacted, what they've said, and crucially, why they're either not available or not appropriate. So then when you make your application, you can put in your witness statement explaining that you've been diligent, your client has not sat on their hands, it's not a funding issue, but you are genuinely struggling. Because keep in mind that judges have a much easier time when they deal with quality expert evidence. It makes their job so much easier. So there isn't a reasonable judge in the country that if you show them you've made every possible effort, will force you to have inappropriate or poor expert evidence just to keep up with a court schedule. It won't happen. So the top tip I can give is keep a log of every time you even think about expert evidence, make a file note, send an email, whatever you might do on your file to record it, so that if you have to make this application, you're in a good position. And again, there's nothing wrong with applying to vary the directions because of experts. They are so important. Get it right. Even if you lose 3-4 months of a dispute, no one will be happy about it, but it is much better than rushing into things. Elliot, like me, will have seen many disputes rushed, or the court timetable has got ahead of them. Don't let that happen to you. Make the application if needed.
Yeah, and just to build on that, the final bullet point you see there is be firm with your expert. I can't emphasize enough the importance of being demanding with your expert and making sure that their report is well reasoned and well structured, because ultimately, like it or lump it, the way these cases are heard, the likelihood is you probably won't have a full-time construction judge hearing a construction trial in the county court. It's likely a judge that's got a general civil background, potentially, or maybe not even that. So the expert evidence is of crucial importance when ultimately a judge is going to be asked to prefer one or the other experts. So making sure that your expert evidence is well reasoned, well structured, and supported by technical data if appropriate is absolutely crucial. And I'll say it for a third time, that comes back to your understanding of the expert evidence and making sure you press them on the points they need to be pressed on. An example of it, I had a case a few years ago where I represented a builder who had been kicked off site in the days leading up to Christmas of a quite substantial residential extension. And there was some dispute about recovering tools and equipment and that sort of thing, and payment of final invoices in the days leading up to Christmas. Thereafter, over the next 3 years, ensued pretty complicated litigation. And when we got to trial, there was no permission for oral expert evidence. So the parties were left to be the only witnesses giving oral evidence. And it transpired that their expert's report was dated the 27th of December, the day after Boxing Day, and only about 4 days after the homeowner had kicked the builder off site. And when we came to cross-examine that party, it transpired that he knew the expert from his local gym. He'd played tennis with him for years, and that's how he'd managed to secure his attendance the day after Boxing Day, which resulted in the judge completely rejecting the entirety of that expert evidence and questioning his impartiality and his Part 35 compliance. Again, that's something which the other side could have got to the bottom of and could have been aware of before getting to a 4-day trial, but they didn't. And they were left in a position where they were effectively hearing their own client sink their own expert in the course of his cross-examination. You don't want to be in that position. So it really emphasises the importance of getting to grips with your expert evidence and really being on top of them.
No, absolutely. We've had a question, a fair fee for an expert involving a residential dispute with around 5 issues. Unfortunately, Elliot I'd be surprised if he is. He may be more competent than I to answer this. I simply don't know. It depends so much on what those issues are. Again, the locality of it and a number and the specialism of that individual. If they're 5 structural issues, you might need a structural surveyor. There may be big issues as to quantum. Unfortunately, it's very difficult to advise on what a reasonable fee is, and we see fees up and down the scale, and it's incredibly difficult to advise on, to be honest. So I'll be surprised if Elliot wants to offer any opinion there, but it's too difficult, I'm afraid.
I would want to go out on a limb and say a figure. It depends on the value. Depends on the value of the dispute. It depends on the nature of the dispute, the issues in the case. Obviously, there are certain areas, not just geographically, but specialist areas of industry and practice that demand much higher fees than others. So it's not really possible to say a figure. There would be a range.
Another quick question. We've had, so it sounds like this dispute, they've had expert evidence from each side, but then the other side have asked for an additional witness evidence on issues arising from the expert evidence. Have you come across this before? Yes, I've seen all manner of things arising from the expert evidence. What I would say is be wary of, is it really something that needs to be rebutted in witness evidence, or is it something they should be dealing with in a question to the expert? Again, it's all fact specific. I don't think it's the most radical or sort of left field of suggestions following expert evidence, but really drill down into whether it's appropriate for a witness lay evidence or just a question to the expert, really. I think that's what I'd say, Elliot. I don't know if you'd have any different instinct on that point.
I'd agree that issues arising out of expert evidence should probably be resolved through Part 35 questions. If the other side are asking you to agree to a direction for further witness evidence, it's probably because they don't like something in there and they want to comment on it. But of course, remember that the deadline for witness statements has probably passed. If you're more than 28 days beyond it anyway, you can't agree to it. They'll have to apply to court. So you could be as difficult as you want. You can either oppose it or adopt a neutral position and let the court make a decision. But even if you do that, there's still a reasonable chance the court will say no, because the intention behind the directions wasn't for the witnesses to start commenting on the expert evidence after it came in. The intention is for the witness statements to be on the factual issues and the expert evidence to be on the expert issues. So I think you'd have pretty good grounds for opposing that, with pretty limited cost risks, to be honest, because at the end of the day, it's the other side who are trying to depart from the directions the court has ordered.
Absolutely. The next slide then, so Scot Schedule, this is really where all of this is leading up to. So a Scot Schedule, to be clear, starting from the outset, it is normally, it's often helpful when it's in Excel format that is easier to play around with. I would say it's, to sort of explain it in the simplest possible terms, it goes through issue by issue, listing what they say the problem is, what they say the remedy is, and what they say the cost of it is. The best Scot Schedules do that in simple and concise format and often make references to the paragraph numbers in their report for further explanation. So, issue, leaky roof; remedy, new lead flashings; see paragraph 4.54, cost, £800 plus VAT. Very simple, very straightforward. The best disputes to deal with are the ones that have this Scot Schedule from the outset. So the moment the claimant's expert report is in, it has one of these schedules attached. If you want to know more information about what should be in them or how they should be formatted or general law advice, read the Technology and Construction Court's guide, read the guide generally, it's helpful, we'll come on to that in due course, but in respect of Scot Schedules, read that guide. Now, yes, you might not be in the TCC, but this is a guide on how the multi-million-pound disputes are dealt with. They are dealt with properly, compliant with the guide. So if your expert follows the guide and does that Scot Schedule in that way, you're off to a great start. Advantages of this: firstly, it assists massively with settlement discussions from the outset, because when the parties are discussing issues, they can be identified so easily. Issue 1, issue 2, issue 3, so on and so forth. You can be really specific about what you're talking about. It really helps the parties engage with, frankly, what is sort of horse trading of, well, we'll concede that issue if you drop this issue, etc., etc. It puts both parties in a position where you can actually talk brass tacks and get that part of the litigation moving. And certainly then when it comes to trial, it helps counsel immensely, because what a good skeleton argument might do where appropriate is go through issue by issue, say which issues are conceded if you're defending. Sometimes the experts may agree on there's a problem and that's the cost of the remedy. So you can concede those. So at a blush, the judge can look and see which parts of the Scot Schedule he can or she can write the figures in, and that can be dealt with straight away. Makes things a lot easier. But then when you come to argue about the issues, again, everybody knows what you're talking about at all times. And this, in my experience, is the best way to get these sorts of cases to settle, where you have it clearly set out. So what you are looking for, the finished product, is claimant expert will say all those phases on one half of the spreadsheet, and then the opposing expert will say their opinion on the other half. And often, once they've had a joint meeting, for example, a lot of those rows might turn green because they've agreed on the defect, they've agreed on the remedy, they've agreed on the cost. So the dispute, you can literally see it row by row resolving itself, or the issues being narrowed. We all talk about narrowing issues in a case, but seeing a Scot Schedule go from Scot Schedule to joint Scot Schedule to joint Scot Schedule after a meeting is seeing that process in action. And it's great to see it makes everybody's life easier. So a good Scot Schedule is much better. And we've had a question, another side's not keen on a Scot Schedule. I would say absolutely get them to engage with a Scot Schedule. And again, at a directions hearing, you can ask the judge to order the experts to have meetings, the experts to put together a joint Scot Schedule. Again, it's very helpful when the first expert comes along and sets the schedule up in an Excel format and gives it to you, and then the other side can add on to it straight away. I've seen that happen. That works very well. But yet, certainly you can really pile pressure on them to engage and have a Scot Schedule put together.
Just on that question as well, I think you'd be pushing at an open door if you went to a directions hearing and you invited a judge to specifically order that their responses should be included in a Scot Schedule, because judges, as much as counsel like them for ease of navigation and litigation management, judges like them even more than we do. So I would be amazed if you found a judge who wasn't willing to order them to provide responses to a Scot Schedule. So I think their opposition to engaging with one will be quite short-lived.
Absolutely. And again, we're making judges, often not specialist judges, lives a lot easier. Next, on to the topic of specialist judges, technology and construction court. First of all, read the guide. Even when you're not in the TCC, there's nothing wrong with lifting example directions from the TCC guide and using those. I've seen that done time and time again. You'll have both counsel coming with the standard directions, which is often lay evidence first and then expert evidence and sort of set time frames. And when you say to a district judge, in the wherever county court, this is the TCC standard, they often just say, absolutely fine, we'll go with that. It makes everybody's life easier. That's what the TCC are doing, so that's what they should do. So even when you're not in the TCC, read the guide, understand the sort of issues that they're trying to curtail, help with, and implement that in your practice running this dispute. Technology and construction more generally, we're only going to really touch this, but consider issuing in the county court TCC list. You'll be dealt with by a specialist TCC judge. The only difference is, of course, you'll be in the county court. The advantages are you get a specialist judge who's much more used to dealing with this, and it will be case managed perhaps more appropriately than what you might have just in the standard county court list. Again, it's difficult knowing when your case is at that suitable level to warrant the TCC list. Often it's very case specific, and I would recommend being guided by counsel in those instances. And if they're in doubt, then they might have the opportunity to canvass it with colleagues or perhaps the appropriate judge, for example. And I sit on the Leeds Technology and Construction Court User Group Committee, and we're always looking at ways of encouraging people to make more use of the TCC list in the county court. So I will have access to ask the individuals, including our own Judge Kelly, who's the Leeds TCC judge, and she's more than happy to deal with queries in broad terms as to when it may fall inside or outside the TCC sort of framework. So always keep that in mind. And if the other side suggests it, don't worry, don't panic that things are going to get needlessly complicated. Of course, there are specialist practice directions and one thing and another, but the guide is incredibly helpful. And the whole idea of the county court TCC operation is that it's accessible. So don't let that sort of worry you off. It really is worth looking at.
Now, I don't want to bore you with the CPR requirements of witness statements, because I'm sure you're all very familiar with them. You've drafted a lot more witness statements than I have. I don't want to teach my grandmother to suck eggs. But that being said, we often see in construction cases witness statements being criticised on for the same sort of reasons, really, the repetitive reasons, which, again, could be avoided. So firstly, witnesses commenting on matters which are not personally perceived by them and not in their knowledge, something that witness statements just should not do at all. And often as well, giving opinions, again, something witness statements should not do whatsoever. The Civil Evidence Act bars opinion evidence, save for when given by experts, of course, you need the court's permission. And if you get either of those two things wrong, so include opinions, or you include matters not personally perceived by them, not within their knowledge, you run the risk of the other side making an application to redact parts of the witness statement, which, one, undermines the effectiveness of your witness statement, but two, probably comes with a cost consequence. So those are the two very basic rules. Avoid those. Don't do those. And then the third one is be comprehensive and thorough. And that sounds rather like a statement of the obvious, but you'd be amazed how many times witness statements get criticised by judges for being brief and lacking in detail. You never really hear of a witness statement being criticised for being too thorough, on the other hand. So if you're going to err on either side, I would err on the side of being more comprehensive and thorough. And a way of ensuring that your statement is being sufficiently comprehensive and thorough is to cross-check it against the pleadings or the Scot Schedule or whatever it is that sets out the nature of the losses, to make sure that each and every item has been addressed in witness evidence. Because even if there is a gap, for example, in the documentary evidence in a case, say, for example, the documentary evidence doesn't address one head of loss, of which there could be 15, 20, but each and every one is addressed in your witness statement, then you always have the possibility of a judge finding your client or your witness to have been an honest witness, a truthful witness whose evidence they accept, and they can find for them on that evidential basis. If, however, your witness statement hasn't addressed all of those issues and it's missed one out, for example, the judge doesn't have that possibility. So always make sure that each and every item in the case is addressed in your witness evidence, and make sure you double check that, so that at the very least you have witness evidence to fall back on, even if the documentary evidence or the expert evidence doesn't support you on a point.
Absolutely. I think the only thing I would add is it's not a forum to criticise the other party. Cut your cloth. Don't let your client take up paragraphs and paragraphs talking about how they caught one of the labourers smoking inside and they didn't wipe their feet and, they never brought the coffee mug back, and general criticism like that. You see it all. It takes up valuable space. It verges on just slinging mud. It's not helpful. So I think the acid test of, do we need this? And will it help the judge establish an issue in dispute? And if you stick within those, then you can't really go wrong. Again, it's a balancing act of being thorough on the one hand, but not wasting everybody's time on the other.
And just like judges are often tasked with preferring one or other experts in a case, there are also cases which come down to the factual lay evidence, and the judge will have to prefer obviously one party or the other, or one set of witnesses or another. So making sure that your witnesses are well prepared to give evidence can really be a very helpful part of the litigation process. So it's very important that you're on top of your witnesses and making sure that they are as prepared as they can be for when they give evidence. Now, of course, it's very important that they understand the court process, they understand the formalities, they understand the practicalities of how they will give their evidence, and make sure that they have an opportunity to ask questions of you about what will happen and what they can expect. That's sort of the start nicely part. Make sure that they're comfortable with all of that, but it can't go on in that way for the entirety of the litigation process, because ultimately, when it comes to the day of them giving their evidence, cross-examination won't be nice, and they won't have it all their own way. The witnesses are going to be challenged. They're going to be cross-examined on factual matters. They're going to be cross-examined on what's in the expert evidence. They're going to be cross-examined what's in the documentary evidence. And they need to be prepared for that. So it's very, very important that as much that you've been nice and explained the process to them in a very nice, calm way, it's also very important that you ask the difficult questions of the witnesses and your clients, because sometimes they need to hear, they need to be told what they don't want to hear sometimes. And you shouldn't be afraid of that. And the way you do that is making sure you ask those difficult questions. And I'm not shamelessly trying to plug for work, but it's often an opportunity when it's appropriate for counsel to come to a conference and effectively carry out a mock cross-examination of the client or the witnesses. One, to test their case and to test their evidence, to check that it's as robust as we think and hope it is. But also it gives them some grounding and preparation for what they can expect at trial. And then in light of that, you're in a position then to tell the client with some reasons what their prospects are. Because you can have the best case in the world on paper, but if when push comes to shove, the witnesses aren't very good, or they're not going to stand up to robust cross-examination, or their recollection isn't as good as they assured you it was in emails and when they signed the witness statement, you're not going to get very far at trial. So it's very important that you know all of those things long in advance of trial, because if you're hearing that for the first time at trial, there's not very much you can do about it. But if you know that well in advance of trial, because you've thoroughly prepared with your witnesses, you've had your conferences with them, you've challenged their evidence, then you're able to act accordingly well in advance of any trial. And that's really all you can do to make sure that witnesses are prepared to give their evidence.
Yeah, absolutely. The only other thing I say, that the worst one I come across time and time again is if you represent the builder, make sure they're prepared that they might have to accept when giving evidence that they've made some mistakes on the job or that wasn't up to scratch. They may well say, well, yes, but I was going to remedy it when I came back. That is absolutely fine. Do not let when you've had expert evidence, perhaps both experts come back and say that wasn't built properly, make sure your builder is ready to accept that they may have made a mistake. You see time and time again, pride getting in the way, and it's not a good look for the builder. It makes them look unreasonable. And if there is any questions of failure to mitigate or having them come back, it doesn't paint them in the best light. So again, as Elliot says, ask the difficult questions and don't essentially, wrap your client up in cotton wool. They are going to face some difficult questions. Next, understand time is getting on, so I'll take it with a bit of a canter. Distress and inconvenience. This is a separate head of loss that you can claim when you've had defective works. Frankly, it's often one that is neglected, sort of thrown in, either forgotten about and never even pleaded, and then perhaps even mentioned at trial and trying to stop sneaking the back door, or it's pleaded but really neglected and not dealt with. You see the main cases up there on the slide. Elliot's going to quickly run us through one or two of the important ones. I think what I would say is just make sure that you properly consider it.
Yeah, I'll do it quickly because I don't want to waste too much time on them. But as Harry says, it's a head of claim which is often overlooked, but it's important for a number of reasons. Firstly, your client probably has suffered some distress and inconvenience, and your duty as a lawyer is to make sure that you advance the entirety of their case. Secondly, these awards are made on a per annum annual basis, and they are awards of general damages, so they are susceptible to inflationary increases. But often by the time that you come to hear a case, there's probably been a couple of years of distress and inconvenience, and it's per claimant as well. So these awards can add up. By way of example, the second case on the list, they're West and Ian Finley Associates. That was a case where the remedial works were in the order of 600,000, but the two claimants had to live in rented accommodation for almost 2 years, which impacted on quality time with their newborn child and that sort of thing. So the fact that they had to move out sounded in £2,000 per annum for one of the claimants and £1,500 for the other for almost 2 years. Vias, the 2016 case, that was £122,000 of remedial work for a residential extension gone wrong. Distress and inconvenience for just over 2 years, £2,000 for one claimant, and again, £1,500 for another claimant. So these sums can add up. They can be the difference between beating offers and not. So make sure you turn your mind to it. Don't overlook them. But importantly, make sure that it's covered in evidence. Make sure it's covered in witness statements, because it can often be overlooked when it's a very easy win, effectively.
Absolutely. That's gets on to the next slide. And make sure it's covered in evidence. Time and time again, you see it neglected, not properly mentioned. If you are serious about it, give it its own subheading in the witness statement. Give it some proper time, some proper thought, because it might just pinch you an extra £1,000 at trial. That might be the difference between meeting a Part 36 offer. And so to answer that question, you plead it as an unspecified sum, just damages generally, and then frankly just see once you've heard all the evidence what you might be able to, submissions you'll make within the authorities. So it's an unspecified sum, but it might just be that difference between a Part 36 offer and not. We've had a quick question going back to the witness stage. In terms of when Elliot said mock cross-examination, that's not what it is. What it is counsel asking difficult questions in conference, so counsel understands that case. It's not a case of counsel then going, well, no, we've heard your answer. Actually, would you consider saying that? That's not what we're saying at all. It's that as counsel, we need to understand what our client's case is. And the important things we need to understand are the exact same things you're going to get asked in cross-examination. So there's nothing wrong with you sitting your client down and saying, well, you've said that you couldn't possibly live with that staying as it is. It isn't that much of an issue. Why can't you just do X, Y, and Z? The other side will want to know, and then they can give your answer. There's nothing wrong with that at all in answering the difficult questions. And of course, really, that's the sort of the stage of preparing a witness statement. How that's done anyway is making sure you cover the issues that the judge will be interested in.
There's another question, Harry, about would you plead distress and inconvenience as a specified or an unspecified sum? And there's no requirement to plead it as a specified sum, because it's what we call general damage as opposed to a special item of special damage. It's not a crystallised loss. So it's general damage that can be left unspecified. It's up to you whether you want to specify it. As a general rule, I don't when I plead distress and inconvenience. And the reason I don't is because you may get a judge who, in light of the inflation of the last couple of years, is prepared to uplift, for example, quite significantly the awards of West or Vias type cases. And if you've limited it to £2,000 a year because that was the sums awarded back in 2016 in Vias and back in 2014 in West, then you may find yourself limited by your own pleading. So I would leave them unspecified on the basis that you may get a little bit more. But it's very important that your witness statements cover the issues. And it's not just saying, I suffer distress and inconvenience. Give some concrete examples of how it was incurred. So, for example, did they have to move out? Did they have to go without hot water for a period? Did they have to live in a smaller property and their children were forced to share bedrooms or things that they didn't have to do before? All that sort of thing goes to support a claim for distress and inconvenience. And if it's not properly set out in a witness statement, you will often find the other side's barrister just won't ask questions on it at trial, and will just say it's not been evidenced because it's not in the witness statement. I've not asked any questions on it. There's simply no evidence for the court to make an award. So you don't want to be in that position. It's something that's very easy to address in witness statements, and make sure that you do.
The next slide, very quickly. And this is in no way tax advice, VAT advice in any way, shape or form, and it may well be not that accurate, but I've come across cases where the claimant, the property owner, has said that they're eligible for 5% VAT on the works because it's works to a residential property. I think it's on the basis that it's what they're going to live in. And of course, that's a big difference from 20% VAT. So what I would say is, if you're defending a claim, especially if it's a residential one and you think they might fall within one of these the VAT exemption, put them to proof on the VAT element, and then it's up to them to come to trial, strictly speaking, and prove that they will be paying 20% VAT as opposed to any reduced rate of 5% VAT. All I would say is it's always worth taking the point. I got a reserve judgment back last week where we pleaded, I think it was pleaded that put them to proof on the VAT element. At trial, they put forward absolutely no evidence that they weren't liable to pay 20% VAT, and the judge awarded only 5%, so a 15% reduction, which was really significant, really worth doing. In that particular case, I think there was some concession that the original works were payable at 5% for one reason or another. They just hadn't established whether or not remedial works would also benefit from the exemption. So keep that in mind. So look at that question early doors. Is your client, and if you're the claimant, paying 5% or 20%? And if that 5% exemption is going to run out when it comes to remedial work, find out and deal with it in evidence if you are put to proof on it.
All right, just before you move on, just had one question about distress and inconvenience, which I'll just address before we move on. So there's been a question, how do you calculate the issue fee if distress and inconvenience is left unspecified? Effectively, you've just got to use your discretion to think what is a reasonable sum that you are likely to recover for your distress and inconvenience, and pay the appropriate issue fee. Is no different to, say, for example, trying to think of other jurisdictions and other sorts of cases, no different to, for example, a personal injury case where general damages are left unspecified, but the solicitors nonetheless have to plump for a figure for the sum claimed in the appropriate issue fee. Same in a harassment case, for example. So you've just got to exercise your discretion effectively and make sure you include something for that when you're paying the issue fee.
So this next on the case of Ruxley Electronics, this again to deal with this at a relative pace. This is a case that everybody dealing with these disputes needs to know about. This was a case on its facts. A swimming pool was built, but it was something like 0.5 metre the wrong size. I think it was too small or too shallow, whatever it was. But it's still usable as a swimming pool, nothing else wrong with it. The other side claimed damages commensurate with rebuilding it to the exact specification of the drawings. The judge ruled that this wasn't recoverable, essentially because it was unreasonable and flying in the face of common sense. This sort of authority has been applied in cases of building defects as well. Max Colombo is a good case there, where reinstatement is the appropriate basis for the assessment of damages. It must be reasonable to reinstate, and the amount awarded must be objectively fair. So keep that in mind. Where this applies is when the remedy suggested is disproportionate or going to cost a huge sum of money for something that you might not think at a glance is a big issue. For example, some example I've had, there's been a gable end of a property. On this particular occasion, it was the end that almost abutted the neighbouring property. There wasn't even a walkway down the side of it, so it was space you'd never see. And the brickwork, the spacings were uneven, so there was more mortar on some roads than there were on others, and it didn't look very nice. But you'd never see it, and it was still structurally sound and was going to cause absolutely no issues. So therefore, was the cost of reinstatement, which was a lot of money to rebuild completely the back corner of this property, was that reasonable to spend? The judge found it wasn't, and therefore they didn't get those damages. This was something that was covered in pleadings, so you should always be alive to this case when defending, And if it is, it needs to be covered in evidence. If your client feels very passionate that it is still reasonable for them to spend that money, put it in evidence and explain why. Don't overlook it and don't neglect it. Because sometimes it is only aesthetic. So another one was a poorly finished patio. Evidence completely silent as to why it needed replacing, why it couldn't just be tidied up and some remedial works going on. And another example, missing trickle vent in a window. I should say in this example, that wasn't the breach of building standards because of when it was put in. One party was adamant that it needed replacing because it wasn't up to their standard, etc. But Ruxley was applied. It was a fairly big window, going to be a fairly big cost, and they could not establish as to why it was reasonable to spend that money, principally because they neglected it in their evidence. So this isn't we could do a talk just about the Ruxley case. What I would say is read the case, read some commentary on it, understand what it is and where you can apply it in your case. It is an extremely good tool to use to bring down claims and to reduce them somewhat.
Harry, we've just had a question on potential for fraud in respect to the VAT point in circumstances where the wider claim is one of construction. Is it perhaps better left to counsel in cross-examination rather than a focal point for pleadings, effectively where there's an allegation of fraud? What I'd say about fraud is tread carefully and take advice from counsel on how to approach it, because counsel may take the view that it's, as you say, best left for cross-examination. There are cases when fraud needs to be put front and centre in the pleadings, and there are cases where it can be used really effectively, whether it's to bring them to the negotiating table, whether it's to secure a very favourable settlement early doors for your client. But the decision on how to approach fraud depends on the strength of your evidence. So counsel is duty bound not to plead fraud unless there is what's called prima facie evidence of it. So any counsel worth his or her salt won't plead it unless they are satisfied that there is evidence of it. But I would say leave it to counsel to make that judgment call about whether it should be pleaded robustly at an early stage or whether it's best left for trial following disclosure and the like. It really depends on the circumstances of the case and the strength of the evidence in support of it and the nature of the allegation. So you're right. It could be best approached either way, but it just depends on each case, I think.
Yeah, absolutely. And often it's as simple as simply putting them to proof on all items of loss and specifically pleading, including VAT and the rate they're payable. I think that's enough, really. You've put them to proof. It's their case to prove. If they want 20% on the back of an expert report, they ought to establish that 20% is payable. It's probably helpful to flesh it out a bit more in your evidence to put, to show that why you think they might not be paying 20%. But I think it's often not going to be a fraud issue. It's going to be more of just a put to proof issue.
One other thing, and the reason why I think it's best left to counsel is if you go all guns blazing and start making allegations of fraud and you don't succeed on them, there's potential for indemnity costs to be made against you. If you make some very robust allegations that you don't succeed on. So counsel should always have in mind the potential cost consequences of whether to plead fraud or not.
Yeah, absolutely. The last slide, and I did say we would deal with some questions that were put in advance, but unfortunately time well escaped us, so we won't have time today. So this will be the last substantive point to make. Part 36 offers. Albeit this has come last, and some of you might be starting to fall asleep. It's probably one of the most important slides. If you're representing the builder, be no doubt the experts will nearly always find something wrong with the works. What the builder will say is, well, I was going to come back and remedy it in the usual snag period. This is standard stuff. But bear in mind, the claimant is always likely to come away with something in their favour, even if it only offsets the claim for the final invoice. It will often be a case of nip and tuck who's going to end up in credit at the end. So the last invoice from the builder might be £10,000. The disrepair might be somewhere between 8 and 15, depending on whose report you're looking at. And it's a case of who's going to be in credit. But even if you're in a position, which I've been in only last week, arguing about costs, where the claimant ends up only just in credit, so the property owner still has to pay the last invoice, but does end up being owed some money from the builder, there's going to be a big argument about who's paying what costs. Because what the builder will say is, well, I've had some success, and they were unsuccessful on lots of issues, and so on and so forth. So offers are really important. They don't have to be Part 36 offers. The more offers you can refer to, the better. But the trick to this is, especially when you're acting for a party that's going to come off not being credit, so a builder who is facing a decent counterclaim or decent claim, make sure your Part 36 offers are pitched reasonably and one that are likely not to be beaten by the other side. And keep that in mind. There's lots of tactics going in. Often you'll be told by your client, well, they'll never accept it even if we make a really good offer. If they're saying that, then in my view, they ought to put the money where their mouth is and make a really good offer. Even if you're not particularly keen on it being accepted, it will be one that you can refer back to afterwards. So costs and the allocation of costs in these county court disputes often far outweigh the amount in disputing damages, often threefold. So get your offers right and keep these in mind. And again, like any litigation, the earlier the better.
Pitching them appropriately is so important. I, a couple of years ago, had a 4-day trial where we were successful, but we missed out on a Part 36 offer by £1,500 when we'd been litigating for the best part of 3 years. And the consequence obviously was significant in relation to costs. The client wouldn't go any higher, but for the sake of £1,500, they didn't get Part 36 consequences for the best part of the 3-year litigation period. So it's really important that you make sure that you pitch the offers appropriately, and include a bit of wiggle room to make sure that certain issues might go against the client, but nonetheless, they can still retain some Part 36 protection going forward. The protection from Part 36 is so important in these cases.
No, absolutely. And I think that's everything we have time for today. I think if we were to go any further, none of you would ever attend one of these talks again. Unfortunately, we have gone on, but hopefully with some interesting points. The next talk in the construction series is Jonathan Ward with the Building Safety Act, an update there. And that's on the 17th of October. Details on the website. So please sign up for that if that's of any interest. Any questions arising from today's talk, and feel free to get in touch with me and Elliot in Chambers. And as usual, thank you very much for attending in such strong numbers. Thank you.
Thank you all. Bye-bye.